So the Supreme Court just fast-tracked a case that could completely abolish firearm permits in all 50 states. And I mean every single permit requirement from purchase to carry. This isn't about tweaking the system or making permits easier to get. Music. We're talking about the potential end of government permission slips for your Second Amendment rights entirely. If you want to stay updated on this massive development and see how it affects your state, hit that subscribe button right now because this is moving fast and the implications are absolutely enormous. The case that could change everything. The Supreme Court has agreed to review a case that directly questions whether states can require permits for firearm ownership and carry at all. Right now, 27 states have constitutional carry laws where no permit is needed, while the remaining 23 states still require government permission through various permit systems. The plaintiffs in this case aren't arguing for easier permits or faster processing times. They're arguing that the entire concept of needing a permit violates the Second Amendment music, because you can't require citizens to ask permission to exercise a constitutional right. What makes this case unprecedented is that it's being heard on an emergency basis. Music meaning, the Supreme Court believes this issue is so critical that it can't wait for the normal multi-year appeals process. This emergency status alone signals that the justices recognize the urgency of resolving whether millions of Americans are currently being denied their constitutional rights every single day. But here's what most people don't realize about music, why this case got fast-tracked in the first place. And it has everything to do with what happened in the lower courts. The shocking lower court ruling that started it all. A federal district court judge did something that stunned the legal community. He issued a preliminary injunction blocking the state's entire permit system, calling it unconstitutional on its face. Music. The judge's reasoning was straightforward. He found zero evidence that the Founding Fathers required permits to own music or carry firearms. And he noted that permit systems only emerged in the early 1900s, often with racist intentions to disarm certain populations. What's remarkable is that when the state appealed to the circuit court, a three-judge panel actually upheld this injunction in a 2-1 decision with the majority writing that requiring a permit to exercise a constitutional right is like requiring a permit to attend church or speak freely. It fundamentally contradicts the nature of rights. Even more surprising when the state requested en banc review, meaning all the judges in that circuit would reconsider the case. The full court declined music to hear it, letting the panel's decision stand. The dissenting judge argued that some historical regulations existed, but the majority rejected this comparison, noting that regulations are fundamentally different from requiring advanced permission to exercise a right. But what's really driving this case forward isn't just the lower court rulings. It's who stepped in to support it at the Supreme Court level. The Trump DOJ's unprecedented intervention. Music. The United States Department of Justice under the Trump administration and Attorney General Pam Bondi filed an amicus brief that goes further than any federal government position on gun rights in modern history. The DOJ didn't just argue that overly restrictive permits are unconstitutional. They argued that any permit requirement whatsoever infringes on Second Amendment rights because constitutional rights cannot be made contingent on government approval and fee payments. In their brief, they pointed out that citizens don't need permits to exercise their First Amendment rights to speech or religion, their Fourth Amendment rights against unreasonable searches or any other constitutional right. So why should the Second Amendment be different? They included statistics from states like Texas, which saw violent crime drop by 4% in the first year after constitutional carry took effect, and Music Florida, which experienced a 3% decrease. But the DOJ's involvement is just one piece of a much larger coalition that's formed around this case. Music, the unprecedented state coalition backing this challenge. Over 25 states with constitutional carry laws have filed amicus briefs supporting this challenge, creating the largest state coalition in support of a Second Amendment case in Supreme Court history. These states, including Texas, Florida, Arizona, Georgia, Music, Tennessee, Missouri, and others, are arguing from real-world experience that permit systems are unnecessary for public safety. They've provided data showing that in the 5 years since many of them adopted constitutional carry, their music violent crime rates either remained stable or decreased, directly contradicting the arguments that permit requirements are essential for public safety. Music. For example, Tennessee implemented constitutional carry in 2021, and their violent crime rate dropped by 7% over the next 2 years. Several of the briefs specifically point out that permit fees ranging from $50 to $300, combined with mandatory training courses costing $100 to $500, create financial barriers that disproportionately affect the very communities most in need of self-defense options. This state coalition adds enormous weight to the case. But there's another factor that makes this situation even more volatile for anti-gun states. The circuit split that forced the Supreme Court's music hand. The reason the Supreme Court almost had to take this case is because of a massive circuit split that's creating constitutional chaos across the country. The circuit court that ruled music permit requirements unconstitutional created a direct conflict with at least 3 other circuits that have upheld various permit schemes in recent years. This means your constitutional rights literally depend on which state you live in. In some parts of the country, courts have ruled you have a right to carry without a permit, while in other parts, courts have said states can require extensive permitting processes. The Second Circuit upheld New York's permit to purchase requirement just last year. The Ninth Circuit has consistently upheld California's permit system, and the Fourth Circuit ruled that Maryland's permit requirements are constitutional. Meanwhile, the circuit in this case ruled the opposite, that any permit requirement violates the Second Amendment. This kind of split forces the Supreme Court's hand because they can't allow fundamental constitutional rights to be interpreted completely differently depending on geography. Legal scholars have noted that this is one of the clearest circuit splits on a constitutional issue in decades. And historically, the Supreme Court takes these cases specifically to create uniform national standards. What makes this even more compelling is that lower courts have explicitly asked for Supreme Court guidance on this exact question, music acknowledging they're operating without clear direction on whether permits themselves are constitutional. But even with all this momentum behind the case, there's a wild music card that could completely derail everything. The anti-gun states' emergency strategy to dodge the ruling. Multiple sources in state legislatures have revealed that anti-gun states are already preparing contingency plans in case the Supreme Court rules against permit requirements. The strategy is simple but clever. They'll try to moot the case by changing their laws before the Supreme Court can rule, which would technically make the case irrelevant because the challenge law no longer exists. New York has done this successfully multiple times. After the Supreme Court granted review in the Bruen music case, New York changed its law. And then after Bruen was decided, they changed it again to try to avoid the ruling's impact. Music California is reportedly drafting legislation that would eliminate the formal permit, but replace it with a mandatory firearm safety certification that would require the same background checks, training, and fees. Essentially, a permit by another name. New Jersey legislators are considering a system where firearm ownership wouldn't require a permit, but purchasing ammunition would require approval for each transaction, effectively creating a backdoor permit system. Illinois Music is exploring whether they could eliminate carry permits, but require liability insurance policies that cost similar amounts and achieve the same restrictive effect. The concern among Second Amendment advocates is that even if they win at the Supreme Court, anti-gun states will just restructure their restrictions into technically different systems that accomplish the same goal of limiting gun ownership and carry. Music. Some legal experts believe the Supreme Court might anticipate this and write their opinion broadly enough to prevent these workaround schemes, potentially ruling that any system requiring government pre-approval or payments before exercising Second Amendment rights is unconstitutional, regardless of what it's called. The oral arguments are expected in March or April, with a decision likely by the end of June, which means we're only months away from finding out whether the entire permit system will be struck down nationwide or whether states will successfully navigate around another Supreme Court ruling. Music. If you found this information valuable and want to stay ahead of every development as this case moves forward, you absolutely need to subscribe and turn on notifications because things are moving incredibly fast. Drop a comment below telling me what state you're in and whether you think permits will actually be struck down, or if anti-gun states will find a music way around it.